All Progressive Congress in Kano State says the Saturday local government elections being conducted by the State Independent Electoral Commission is illegal. A chieftain of the party, Rabiu Bichi, made the remark in an interview with the press on Saturday in Kano. He said the party's stance is informed by a court order by Justice Simon Amobede of the Federal High Court, Kano, which still stands and which has rendered the election null and void. The judge ruled that the leadership of KANSIEC was partisan and biased towards the ruling New Nigeria People's Party in the state. Since the judgment has not been appealed, the APC considers any outcome of the election illegal. The APC chieftain also pointed to a recent Federal High Court judgment that squashed all NNPP chairmanship candidates for the election, which he said had further reinforced the party's claims that the election is illegal. He, however, urged all members of the party to exercise restraint and await the final outcome of the legal moves being made by the party to challenge the conduct of the polls. ATN reports that the KANSIEC chairman, Professor Sani Malumfashi, insisted that the commission is conducting its activities within the bounds of the law. Every activity of the commission is procedural. We are not partisan, he said. He stressed that all Democrats and advocates of democracy are expected to respect Friday's Kano High Court judgment, which authorized the election to proceed. Earlier on Friday, Kano State High Court number 15 affirmed KANSIEC's jurisdiction to conduct the Kano State local government polls scheduled to be held on Saturday, 24 October 2024. In his judgment, Justice Sanusi Ado-Maji stated that the applicants had successfully proved their case. Ugochukwu, what do you make of this? Now, it appears that there are judgments for and against. One, a state high court ruling in favor of KANSIEC to go ahead with the elections. And then, barely 24 hours to the local government polls, a federal high court, disqualified all the members, all the candidates of the NNPP. However, Governor Yusuf still went ahead with the local government elections. And guess what? These members, the 44 NNPP candidates that were otherwise disqualified by the court, emerged as winners of the 44 local government areas, and NNPP also cleared the 484 councillorship seats in Kano State. Go ahead.
This is drama because you could see he's not even sympathetic to even one political party to give out a local government.
NNPP won all.
That's what I'm saying. In River State and in Cross River State, they were so magnanimous in giving out or letting out one local government each to their sympathetic political party, as the case may be. But what happened in Kano is this. I will try to look at it from what happened in River State and the potency of the case instituted by the APC, led by the faction of Tony Okocha, when he held swear as the CTC APC chairman in River State. The potency of his case emanates from, inclusion of INEC in that particular suit, and the process leading to an election. Election is not an event. That's why I continue to describe what happened in River State on the 5th of October 2024 as an event which lacked process accumulating into the finality of that. Electioneering process starts at least 4 to 3 months so that people know that there are lines and legs before the final day of the election, which is when the CX are expected now to carry out their own functions. But there are functions left for the political parties to be monitored by the CX, knowing whether it's in conformity with what the rules and the laws, as the case may be, is being followed. But what happened in Kano State, where I have not followed it very well, I don't know what the prayers of the APC in Kano State might be. I don't know what they elicited their prayers to go to the Federal High Court. If they did not include any of the federal institutions like INEC or the Nigerian police in their prayers to the Federal High Court, it is a nullity, because this is a state affair. And the Constitution has given the House of Assemblies the mandate to make laws for the good governance of the state. So unless there is, like what happened in River State, that's why I painted the picture of what happened in River State, unless in the prayers of the APC in Kano State, there is any of the federal institutions that were found wanting, or that is in breach or in affiliation to now conduct an illegal election in their own purview.
The judgment of the Supreme Court, yes, of the Federal High Court,
yes,
disqualifies NMPP members.
Now I'm coming to that.
You're mixing it up when you say it is the State High Court that empowered KANSIEC to go ahead with the election.
Okay.
However, there is a different
You say
judgment.
This one happened on Friday.
The one of the State High Court gave KANSIEC power.
For the potency to go ahead.
Yes. Now, Federal High Court, there are two different judgments here.
Yes.
Federal High Court did not stop KANSIEC from going ahead with the elections. The Federal High Court judgment disqualified the NMPP candidates.
So what's the prayer of the APC?
However, APC is saying that the election is illegal. And they said there is a subsisting court judgment.
That is the way I'm coming.
That is on one hand.
Yes.
Now, they also quoted the judgment of the Federal High Court disqualifying the 44 NMPP candidates. However, the governor still went ahead to conduct elections with this disqualified candidates. Yes. And they emerged as winner. Now, the question would be, Ugochukwu, the incessant disrespect of court judgment by governors in Nigeria, probably because they have immunity and cannot be held liable for whatever it is that they are doing while they are on seat. But isn't it at this point a culture? Isn't it worrisome that the judiciary will give an order or a judgment, and the executive at the state level will choose what to obey and what to not obey? Isn't it worrisome? Because, I mean, this was part of what played out in River State. And this is also what is playing out now in Kano State.
Why I may not mix it up is this. There are 3 legs to the cases in Kano State. But why I'm saying I don't know the prayers of APC in Kano State in the first, in the subsisting judgment. That's where you didn't understand me clearly. I was reacting to the subsisting court case. That is why I said in that particular first case they instituted, what were the prayers? What elicited the prayers of APC going to court? That is the only thing that can nullify that particular election. But if it is about the Federal High Court nullified the candidature of NMPC members, I will tell you that for free, that one holds no water. You know why?
Okay,
it is an
instance, the one you spoke about the first time.
Yes.
The judge, Justice Amobede, actually said that KANSIEC was biased towards the NMPP. Do you understand? KANSIEC was biased towards the NMPP. So now,
without any concrete, any mentioning of what led to the KANSIEC being biased. You cannot blanket
for want of time. We are not going to delve into all the prayers and all
I understand, but the prayers is what gives the potency That is what I'm trying to tell you. For there to be an appeal, or for there to be in the... No, there's something I'm saying, understand me. I say that now that the election has been done and dusted, for there to be an appeal that will now nullify at the end of the day, even if it gets to the Supreme Court, that at the end of the day, that election will be considered a nullity, is the potency of the prayers emanating from the lower court. The lines and the letters of what APC is praying as an infraction committed by KANSIEC. That is what I'm trying to say. That is why I gave my example with what happened in Rivers State, where clearly the APC, led by Tony Okocha, we saw the clear prayers they made, and which are potent enough to bite. Which are very potent to bite and bring down and rubbish whatever happened in October 5th, 2024. That is where I'm laying my emphasis on. If it is about the Federal High Court nullifying this...
Let me give you further clarity.
Yes, give me the clarity.
All right. The Federal High Court judged that KANSIEC chairman and its members were card-carrying member of a political party.
You can't substantiate that. You can those things. That is why I'm telling you that is just a blanket. It's an accusation.
Hold on.
Okay.
Hold on. You are getting ahead of yourself. If I before, when you make that statement, you just cast aspersion on the judge, because a judge will look at the merits of a matter before him. And a judge cannot give a judgment without, if you're claiming that somebody is a card-carrying member, it was substantiated in court. So you are here saying you don't know the details of the matter. I am furnishing with the details of the matter, and you're saying I cannot substantiate that.
No, I mean the people who went to court.
That went to court and was substantiated, and it was on that basis that the judge gave his judgment, and now said that
the first instance,
these people, the judge fired KANSIEC chairman and the KANSIEC members. He fired them and said that they are card-carrying members of a political party. And I think some of the members were not up to the level. I think in civil service you have to be up to level 16 or so.
Before you
and some of the members were not up to that level
to hold such
offices. To hold such offices as state electoral
officers.
Yes. And the judge, in his wisdom, having looked at the matter before him and the evidences before him, gave judgment. Now, on one hand, it has been established by the court that the KANSIEC chairman and the members are card-carrying members of a political party, and that made them biased towards that party, and the judge fired them. Now, another judgment fired the NMPP chairmanship candidates. However, a lower court said that the KANSIEC had the powers to conduct elections. And the governor chose to go with that, and the KANSIEC chairman, of course, from his statements, chose to go with the judgment of the lower court.
Can I come in?
Yes, I'm sure now you are furnished with the details.
I'm following with the details. The details for me does not hold water. Do you know why it does not hold water? KANSIEC, let's remember, is within the jurisdiction of the governor and his powers to appoint and send to the House of Assembly to screen. And those people are conducting election in Kano State. Let's just, you see, this particular, I am so grateful that you have laid out the meat. This is the problem that the camp of the governor in Rivers State is having. The cases that have merit in different courts. A case that have merit in Federal High Court, he will run to the State High Court. At the end of the day, the question of jurisdiction comes into play and makes a nuisance of the whole thing. Why will APC institute a case bordering on KANSIEC to the Federal High Court when you're dealing with matters within the state? Does that Federal High Court have the jurisdiction to entertain such matters? This is one. This is one, because everything you're talking about is Kano State. And those appointed are civil servants in Kano State. The governor can decide to, the State Civil Service Commission can promote her members at will. they can also retire people. People can retire and also take appointments. This is within the purview of the state. It is not federal. Loresha, be taking note of what I'm saying, so that at the end of the day, I want to know why the APC in Rivers State, if there is no federal organ that they are attaching to this suit that made them go to the federal level, to the federal high court. That is where my point is going. And if it's coming to the second leg, that maybe the primaries, or how the NMPC handled their own primaries, it is not for the courts to decide. It is only someone who is an aggrieved member who contested that particular primaries within the party that has the locus to go and challenge the outcome of whatever shenanigans that political parties have done. Matter. Yeah, but I'm just saying
that... Hold on, the police were and other security agencies which were federal institutions.
We are involved.
We are also involved in this matter. In fact, let me read the judgment to you.
Okay.
So you get more clarity. Federal High Court sitting in Kano has disqualified the chairman and members of the Kano State Independent Electoral Commission, KANSIEC, from conducting the scheduled local government elections in the state. The court ruled that the KANSIEC chairman and other members of the commission are card-carrying members of the ruling New People's Party and also are not civil servants above grade level 14. This is coming barely 4 days to the the Kano State local government elections, scheduled for October 26 on Saturday. The court, presided by Justice S.A. Amobede, made the declaration while delivering judgment in a suit filed by Aminu Aliyu Tiga, an All Progressive Congress member, against KANSIEC, the State Attorney General and Commissioner for Justice, Barrister Haruna Isa Dederi, and 14 others. According to him, the defendants, being card-carrying members of the New Nigeria People's Party and in partisan politics, contrary to Section 197, subsection 1B and Section 200, subsection 1A of the 1999 Constitution of the Federal Republic of Nigeria as amended, and Section 4 of the Kano State Independent Electoral Commission Law 2001, are not qualified to be chairman and members of the defendants, KANSIEC, in this instance. Yes. The judge further ruled that Kabia Zakirai, the secretary of the commission, not being an officer in the Kano State Civil Service, not below the rank of director prior to his appointment as secretary of the commission, is not qualified to be appointed to the position pursuant to Section 14 of the Kano State Independent Electoral Commission Law 2001. The judge added that the first defendant, KANSIEC, whose composition of members was made in contravention of constitutional provisions of Section 197, subsection 1B and Section 200, subsection 1A of the 1999 Constitution of the Federal Republic of Nigeria as amended, and Section 4 of the Kano State Independent Electoral Commission Law 2001, cannot validly and competently conduct local government election 2024 in respect of 44 local governments in Kano State until and unless qualified persons are duly and legally appointed as chairman and members of the commission in line with relevant extant laws. Justice Amobede further ruled that whatever the commission did or has done or is doing in preparation of 2024 local government election in Kano State, such as issuance of election guidelines, circular screening of candidates, sale of nomination and expression interest forms, whichever and howsoever, are null and void and of no effect whatsoever. The defendants are forthwith disqualified and removed from their positions as chairman and members of the commission. The first defendant, KANSIEC, is forthwith restrained from conducting 2024 local government election in respect of 44 local governments in Kano State until and unless qualified persons are duly appointed. The defendants are mandated forthwith not to participate and monitor the conduct of the local government election 2024 in Kano State, and until the Constitution, the 1999 Constitution of the Federal Republic of Nigeria as amended, and sections 4B and 14(1) of the Kano State Independent Electoral Commission Law 2001 are fully complied with in the appointment of qualified persons as chairman and members of the first defendant. Justice Amobede directed the police and other security agencies to forthwith ensure full compliance with the ruling. I hope this is clear enough for you.
Yeah, they will go on, the NMPP will go on appeal, is subject to appeal, and the whatever evidence or findings APC presented is subject to be investigated and it is left to be found out whether those infractions are true or not. Then until that happens, it is still left for the courts to take the final decision. But what has been happening in Nigeria, the Kano State government has not been an exception. They have gone ahead with their elections, and until otherwise stated, they have chosen what to...
Which still brings up back to the first question I asked, which I said it's a concern and actually a menace right now, where the executives of states across the federation choose not to obey court orders or court judgments, as it were, or they choose to go for the orders that suits them.
You know, when a particular character or when a particular behavior, you know, is allowed to fester, it becomes a norm.
Okay.
We are sitting here today, we are trying to say it should be done this way, just like some of the Nigerian leaders, when they leave office, they begin to see it clearly and see it right. You understand? So when they see it, they begin to see it clearly. But I tell you for free, this didn't start today, and with the powers that the governors will, and the necessary tinkering of those, you know, conflicting portions of the Constitution have not been touched. You see the kind of amendment to the Constitution they do, the ones that favor them. They're not looking at those nitty-gritty, but the governors are drawing their powers and whatever they are doing inherent in the Constitution. Because the Constitution has, Section 7 has stated how they look, the House of Assembly is empowered to make laws for the good governance of the state. Whatever is described as good governance.
Whatever the laws, whatever, you know, that is
what they do.
The Constitution also said, clearly, it's explicit, that no other law or constitution is supreme to the Constitution of the Federal Republic of Nigeria. Yeah. So when state houses of assembly makes laws that are not in alignment with the Constitution of the Federal Republic of Nigeria, it can be challenged in court.
Yes,
and it can be made a nonsense of.
It can only happen that way if they are the sex are also drawing their powers through the Electoral Act as amended. But you now understand that they are making their own laws.
The judge also drew his judgment from the Constitution, 1999 Constitution as amended, and from the Kano State Local Government Law number 4 as well, which means the KANSIEC Constitution, the
Kano State,
the KANSIEC Constitution in this instance, the chairman and the members that constitutes the KANSIEC in this instance, you know, the constitution of these KANSIEC officers are not in line with Kano State Electoral Commission law.
From
what the judge has said,
the judge is not praying.
In line.
The judge
cannot pray.
No, the judge is making his ruling based on what has been furnished with, is it not? That those people were not qualified, so to say. And then he now went to the Constitution and the Kano State Constitution and the Kano State law, which establishes the KANSIEC, and then made his rulings, is it not? Then when those people go on appeal, they will now also present those allegations that have laid against those officers to the higher court, and they will now look at the merit and the dismerit.
This is why this still brings us back to the first question. That it is taken to the appeal court, and appeal court gives judgment. It's not a guarantee that Governor Yusuf will obey it. Just like other governors.
That is why I said this issue, Laurentia, did not start today. And we have not, the National Assembly are only doing frivolous amendments.
All right.
These biting and conflicting amendments, Seko, are the ones that we ought to have, you understand,
yes,
looked into, and then we begin to nip those things in the bud.
All right.